Good morning, happy Pongal, happy Magar Sankranti. From today onwards, the sun start sending rays from the Magar group of stars place. That was the entire 360 degree through which the earth rotates the sun is divided into two parts. That one of the part is Magar Rasi. So from today onwards, the sun will rise from that particular place. Therefore, the North Indian people, including Andhra Pradesh, Karnataka, Kerala, they celebrate Magar Sankranti. Here we celebrate as Pongal. Okay, now the very interesting subject which I want every young lawyer should understand and know the procedure, how to get over with the labor's problem. What all are the ways, how to understand the labor law. So I have multi-number of times I told you that the labor law provisions are available in the Factories Act originally, then thereafter Industrial Dispute Act, then so many acts are there, Workmen Compensation Act and what not, Insurance, ESI, payment of the minimum wages act, so many things. Now, to understand the labor procedures, first of all, you should understand who is workman. The word workman is most essential. If you are working industrial dispute between the management and the workman. So, the section 2S clearly distinguishes who all are the workmen, who all are managing. That means functioning as a supervising authorities. So this judgment AR 2024 Supreme Court 5409 AR 2020 Supreme Court 5409 the judgment was delivered by our beloved Judge Justice R. Mahadevan. This deals with section 2S Schedule 2 Item 3, then section 25F, 25G, 25H. Here you try to understand first the problem was he was originally appointed as a junior engineer, thereafter promoted as assistant engineer. So while functioning as assistant engineer, he has to supervise two junior engineer. Therefore, when his services were terminated, initially he raised conciliation proceedings. First step is conciliation proceedings. And the appropriate authority, conciliation officer, said there was a dispute, industrial dispute. Therefore, industrial dispute case was numbered and the labor court has passed an order reinstating the employee with 75,000 company in lieu of back wages. Then what happened? Thereafter, they went to High Court. High Court allowed, partly allowed the writ petition and partly not allowed. Therefore, both appeals went to Supreme Court. Supreme Court has clearly stated what is 2S of the industrial dispute. Nature of workman defined under 2S. The nature of work done by him, not merely on the designation of his post. So that is most important. Whether or not an employee is a workman, under section 2S of the ID is required to be determined with the reference to principal nature of duties and functions, and the designation of employee is not of much importance, and what is important is nature of duties being performed by the employee. Now you see, merely having a junior does not make an employee or supervisor managerial cadre. Merely having a junior. Then thereafter sections are dealt. So you see, the workman can approach the labor court. That definitions was again reiterated at paragraph 11 of the Industrial Dispute Act. The following persons are not eligible to approach labor court, that is Air Force Act, Army Act and Navy Act, police service or employees of prison who is employed mainly in managerial or administrative capacity, who being employed in supervisory capacity draws wages exceeding 10,000 rupees per month. So these all are the definition of here. Admittedly, this junior engineer who was promoted as assistant engineer was controlling 2 persons, supervising their work. Therefore, the Supreme Court has held neither he is entitled to be treated as workman nor he is entitled for reinstatement under section 25 F, G, all these things are there. F, G, 25H, where the remedies are described. Therefore, kindly go through the judgment deeply. Lot of discussions were there, very helpful. And one more thing I have to explain is, suppose some mestris may be there. Though mestri may be supervising the work of his masons and sitals and perials, but still he participate in the work. Like some people working in the port and railways are there, when some workmen are working, he will be there to control and give instruction. In the industries, one man can watch 5 persons who are working as a fitters, but whenever required, he immediately go and check and recheck, and he actively participate. Therefore, all they are considered as workmen. These all are the most important judgments are there in industrial dispute labor laws. Best wishes.